akwanhyia ɛhyɛn akwanhyia kɛseɛ bi akɔso ɔman konkro Ghana mu anya asɛmpeto. That is the accident in Alan Kojo Chamantin any hopes in Adre. Abusia for his young summer to a Johnny said, this young Yankopon, the Alan Kojo, a year hopes in Adre, who are for Fiam Alan Kojo Chamantin or Dia, Sabia to say, a doctor for a guso Erhena Nessa, Abusia for in Sembe, Nekawa, the Besumonans and a high and Casa TV. Cause also subscribe like Nasa social memory and fee, so be me other man. So the bitma also in your beer in beer day at
That is it. That is why I am surprised by the outcome. But of course, it's not the end of it. I mean, Obi, what we say, this is not the first setback in my effort to prosecute these financial crimes. Even open case in Pono, I had a setback. The same submission of no case ruling, which was made by the former judge, I think Justice Konyanuga, for Supreme Court first. Surprisingly, Supreme Court ruling by Justice Konyanuga. I had to go and review. I had success on review, and the ruling was reversed. The Samba High Court said we should have open defense. Then there was an application made, and the trial judge then said we have to start afresh. We have to start de novo because by that time Justice Konyanuga again under strange ruling. It was one that really was also against all reasonableness. I took it in my stride and I appealed against it to the Court of Appeal. And as I said, just as it's normal, just as me I'm used to, but I appeal against this one. And I'm very sure that it will be set aside. But really, the ruling there, in my respectful view, most unreasonable, and it goes against the essence of all the authorities on coercive financial laws. Indeed, there is no case as clear as this one. There's no case in which the ingredients of coercive financial laws have been established in as lucid a manner as this one.
But Cousins, how kind the Court of Appeal decision now, Minya BNC 125 pages. But I was just taking a cursory look. So I'm share because I majority in Joshua 2-1. So we'll share the first justice our cut 2 justice akabuafo paragraphs 149 150 151 of the decision now okawa 149 or said the evidence further establishes that the ambulances were initially parked at the forecourt of the State House, but they were moved to the Air Force Base at Burma Camp by the National Ambulance Service at the direction of the Ministry of Health sometime in November 2015. Mr. Foster Ansong Brijan, PW1, who testified on 31st May 2022 said, quote, looking at the time we parked them there, the current state, the vehicles have actually deteriorated, unquote. 150 or say, my lords, if the above is accurate, in my respectful opinion, it defies logic that Jakpa at Business, agent of the supplier Big C, would be charged with causing financial loss to the state based on the fact in the record of appeal when the plan put in place to rectify the defect of the ambulances to enable their use has not been implemented because the government failed to meet its obligations under the roadmap agreed to in 2016. In any event, that roadmap leading to the shipment of the part to Tema Port was agreed upon between the Ministry of Health and Big C, not with Jakpa at Business. So it is not clear why Jakpa at Business would be asked, quote, to go and pay and clear the item to rectify the anomalies on the ambulances, unquote. As a corollary but to the foregoing, it bears mentioning that if there are vehicles, even if deficient in certain requisite part, parked in Ghana, an action plan in place between the MOH and the supplier Big C to rectify the deficiencies and additional parts or accessories in storage at Tema Port for the said rectification, then there is a need to reassess the quantum of the alleged loss a factor that impacts the case against all the accused in this case, and calling into question the maturation of the charges preferred against the accused persons. It's essentially, the justice of the court.
Yes, I heard everything. But the point, the judge, with all respect, misses the point. The financial loss was caused not because the vehicles were parked at the forecourt of the State House and were moved to a different location and were left to the vagaries of the weather. The financial loss was caused in the first place when the wrong specification of the vehicles were even supplied. Number two, the financial loss was caused because the vehicles that came were not ambulances, were not fit for purpose, and indeed could not be converted into ambulance. And I've told you that indeed there was a report from Ministry of Health and National Ambulance Services which show that the vehicles that were supplied were so fundamentally defective that nothing could be done. And indeed, this report from the license dealers in Mercedes-Benz showed that the vehicles that were actually supplied could not be converted into ambulances. In this, with just vehicles, see one more 10 days to 100 years to 10 weeks exit material. In the first place, the vehicles should not have been supplied. Wrong specifications supplied, not fitted with the relevant equipment, indeed could not be converted into ambulances subsequently. And if indeed a ßreak which now converted into ambulances, from the part you really read, this thing that you're talking about occurred in 2015.
Yes.
The movement. How come from 2015 now until 2017, our NDC for legal officer, they couldn't convert it into ambulances? How come they couldn't fix the equipment? Because it couldn't be converted into ambulances. And that is not based on the oral testimony, it's based on documentary evidence from the license dealers in Mercedes-Benz, which we have stated in evidence at the trial.
Then based on what?
No, but the point about the fact that even the court for appeal was split in the judgment,
yes,
supports my view. Say the judgment itself is not sacrosanct. Is not one that cannot be impeached, because even when the court for appeal was divided, it was a majority decision 2-1.
Yes.
And everything in my training and upbringing would dictate that such a judgment ought to be questioned. We have to test the soundness of the decision at the Supreme Court. Not as a matter of test the soundness. For me, it defied, with all respect, every reason. Because yes, the vehicles were supplied. Number one, the vehicles were wrong, were not the ones specified under the contract. Number two, the vehicles were bereft of all the necessary ingredients, as somebody would say, for one better expression, the necessary features of an ambulance. They didn't have all the equipment. Apart from that, they were defective. Even the engine capacity, the engine size that was set out in the agreement, the body and all that, all the interior parts were different from what was supposed to be supplied.